Court does call the case of the People versus Mars. Is it Casayatulin? Did I get that close? Probably not.
It's very close, yeah.
I direct. We're starting this docket with something that might look routine, but it's actually one of the most critical moments in any criminal case. An unrepresented defendant entering a plea. Judge Simpson immediately establishes that this man does not have counsel. That's not a small detail. That's constitutional territory. The Sixth Amendment guarantees the right to an attorney in criminal prosecutions, and before anything moves forward, the court must make sure that right is knowingly and voluntarily waived. Now notice how deliberate the judge is. He explains the maximum penalty, 90 days in jail, $500 fine, plus costs. That clarity protects the record. If this defendant later claims he didn't understand the consequences, the transcript says otherwise. And then comes the no contest plea. Legally, that's powerful. A no contest plea means he's not admitting guilt outright, but for sentencing purposes, the court treats it exactly like a guilty plea. This is where many defendants underestimate the weight of that decision. No trial, no witnesses, no cross-examination, no appeal as of right. Everything ends right here. So ask yourself, would you ever walk into court without a lawyer and make that call alone? Because that's exactly what just happened.
Conrad Solar on behalf of Pittsfield Township.
Your name, sir? I did do pretty good. Yeah, okay.
Your Honor, I've spoken to the defendant. He is not represented by counsel.
Yes.
I'm going to add count 2 of failure to report an accident under MCL 6.22.
622.
He's going to plead no contest. I've discussed with him the license ramifications of the charged offense as well as the charge that I'm adding, and he wants to plead no contest.
Is that a correct statement, sir?
Yes.
All right. You are here, and this is a criminal charge. You aren't represented by counsel. The maximum penalty in this case is 90 days, $500 fine plus court costs. I do have to advise you that if you decide you want to be represented by counsel, the court would permit you to be represented by counsel. You understand that, sir?
I understand it.
Okay. And so, is it your decision that you do not wish to be represented by counsel?
Yes.
Okay, very good. May I have him sworn?
Raise your right hand. You solemnly swear affirm to tell the truth, the whole truth, nothing but the truth, so help you God.
Yes.
State your name correct.
All right. Sir, it is this court's understanding that you are going to be pleading no contest to the charge of failure to report an accident. That is a misdemeanor punishable by up to 90 days, $500 fine plus court costs. Do you understand that?
Yes.
All right. Do you understand what a no contest plea is?
Yes.
Okay. Two things about it I have to make sure that you understand. First thing is that it means that you're not further desirous or wanting to contest this charge. You understand that?
Mhm.
Is that a yes?
Yes.
Okay. The second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes.
All right. The basis for this no contest plea?
I think he's civil liability.
Civil. Okay. All right. So, sir, to that charge, how do you plead? Okay. Let me ask it this way. Do you plead guilty, not guilty, or no contest?
No contest.
There you go. Now you understand that by pleading no contest, you will not have a trial of any kind.
This is the moment where rights are formally surrendered. Listen carefully to what the judge lists: the right to call witnesses, the right to confront accusers, the right to remain silent, the right to be presumed innocent. Those are not procedural technicalities. Those are pillars of the criminal justice system. And here's something important. The judge is not rushing this. He's methodically confirming understanding. Courts must create what's called a knowing, voluntary, and intelligent plea. If any of those elements are missing, the plea can be attacked later. That's why this feels repetitive. It's intentional. Also notice how the defendant hesitates earlier when asked how he pleads. That slight confusion, it matters. Judges are trained to slow down when they sense uncertainty, because once that plea is accepted, the train moves fast towards sentencing. Let me ask you this. Do you think most defendants fully grasp what they're giving up in that moment? Or are they focused only on getting it over with? Because the difference between fighting and pleading can shape your entire record.
Yes.
All right, you don't see an advice of rights form. Because you're not having a trial, you understand that you're giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. You understand that, sir?
Yes.
You understand you're giving up your right to appeal of right. Okay, let me, you understand that?
Yes.
All right. Are you on probation?
No.
Okay. Are you on parole?
No.
All right. Has anybody promised you anything other than what's been stated here today to get you to plead to this charge?
No.
All right. Anybody threaten you or coerce you?
No.
All right. You're doing this voluntarily
Yes.
and of your own free will.
Yes.
All right. The court has been provided Pittsfield Township Department Public Safety Report for their case number 2414834. Any objection to the court having reviewed that report?
No, Your Honor.
Do you have any objection to me looking at the police report, sir?
No.
Okay. Based upon the court's review of that police report, the court does believe that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Counsel, have I complied with the court ruling? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Now we're at the factual basis stage. Even with a no contest plea, the court must determine that there is enough evidence to support a conviction. That's why the police report is referenced. The judge isn't just rubber stamping this. He's confirming there's a legal foundation for guilt. And then count 1 is dismissed. That's significant. Dismissals are leverage. It suggests negotiation happened behind the scenes. Plead to count 2. Count 1 goes away. That's how plea bargaining works. Streamlined justice in exchange for certainty. Notice there's no restitution, no victim claim being discussed. That narrows the scope of harm. Then comes sentencing immediately, which tells you this is likely a lower-level misdemeanor with minimal dispute. But here's the real takeaway. The defendant avoids jail today because the 90 days are suspended. Suspended time is conditional freedom. If he violates again, that suspended sentence can be activated. The court has now placed him on notice. Would you see that as leniency or as a warning shot?
Sir, do you wish me to accept your plea in this case?
Yes.
All right. Court will accept the defendant's no contest plea to this charge. To count 2, count 1 is dismissed. Are there any issues of restitution involved in this? Do you know?
No, Your Honor.
No issues of restitution. Is there any objection if I sentence the defendant now?
No, Your Honor.
All right. Sir, is there anything you want to tell me before I impose sentence in this case?
No.
Okay. Fines and cost of $350. I'll suspend 90 days in jail. When can you pay that?
Maybe even today.
Today, you think?
I think so. I got to check my pockets.
Okay, let's do this. Pay it by the 31st. Get it paid by the end of the month. Can you do that? All right. Pay it by March 31st, 2025. All right, you're all set. Thank you, sir. Thank you for working it out. Court does call the case of Finney versus Sedona.
And just like that, we pivot from a clean misdemeanor plea to a civil case that already feels complicated before anyone even finishes introducing themselves. This isn't criminal anymore. This is landlord-tenant territory that has clearly evolved into something much deeper. Right away, we hear non-jury trial. That means Judge Simpson is the sole fact finder. No jury buffer, no persuading 12 people. Every argument is going straight to the bench. That changes strategy entirely. Lawyers tend to argue tighter, more technical points when it's just the judge deciding. Then we get a procedural issue on the day of trial. That is rarely good news. When someone announces a procedural issue at trial, it often means they're trying to delay, dismiss, or redirect the case. And courts, especially after years of litigation, do not appreciate surprises. This case already had an eviction order. There's a counterclaim pending. And now there's talk of summary disposition under MCR 2.116C8 and C10. which in plain terms is a request to throw the case out, either because the claims legally fail on their face or because there's no genuine issue of material fact. Translation: one side is saying, we shouldn't even be here today. The question is, will the judge agree, or is this about to backfire?
Good morning, Your Honor. This is Megan Dogwalla on behalf of the plaintiff, P84205. Mayor, can you state your name?
My name is Maria Payne. It's representing
Peterson.
All right. It's a date set some time ago for a non-jury trial. Are the parties ready to proceed?
Your Honor, may I approach the bench and go off the record briefly before I begin? I have a procedural issue.
A procedural issue?
Yes, I can stay on the record.
That's fine.
Oh. May I-
What? No, well, then I've got to have them up here.
Sure.
I guess, what is it?
Okay, so there is a counterclaim, which is what this is separate full trial. There was already an order of eviction entered. I'm intending to move for summary disposition under C8 and C10. I need the opportunity to brief that issue.
Well, why am I here on the date of trial with that?
Right. So the last motion that was filed, it was back in July. I appreciate that this is a long time coming. So please, Your Honor, I'm not appreciating that for its time. However, I'm recently retained and there's about 1,000 pages worth of evidence. This has gone to mediation. There's conflicts in the facts, even in what was submitted during mediation. And there's significant evidence indicating issues of fraud upon the court and other issues regarding insurance fraud by the defendants. And it is my professional opinion that it does substantiate claims under MCR 2.116 C8 and C10.
Well, the motion should have been brought before today. I mean, I don't know what particular issues you're talking about in terms of somebody committing fraud upon the court. And I'm just going to say this, if they were going to say this about the other side, if you're going to make that accusation, counsel, you better bring it.
This is the moment the courtroom energy shifts. Fraud upon the court. That is not casual language. That accusation means someone intentionally misled the judicial system. Judges guard the integrity of the court fiercely. When that phrase is used, the burden skyrockets. Listen to Judge Simpson's warning. He's not yelling, but the message is unmistakable. If you're going to allege fraud, you'd better have substantial proof. Because if you don't, credibility collapses. In litigation, credibility is currency. Once you lose it, every argument afterward gets filtered through skepticism. Notice something else. The attorney says she was recently retained and there are 1,000 pages of evidence. That suggests she came in late. Coming in late to a long-running case is difficult. You inherit procedural history. You inherit strategic decisions. And you inherit deadlines. But here's the tension. Is this a legitimate fraud concern, or is this an 11th hour attempt to reframe the battlefield? What do you think? Is this strong advocacy or risky overreach?
And it better be that, because if it's not, then I'm going to be exceedingly angry because I don't like people. I do not like people accusing others of things like that without substantial proof.
Absolutely. It is a substantial issue in this case. My client's rights have been significantly violated. It's
By whom?
by former tenants. This started out as a non-payment of rent case. As I mentioned, there was an eviction action, there was an order of eviction. As you're aware, we're here on the bench trial for the counterclaim. I don't take a claim of fraud upon the court lightly. There is significant evidence to present that. And I don't want to disparage my client's rights by not attempting to have this dismissed under C8 and C10.
Well, I get it, but there was an attorney in this before.
He's exceedingly difficult to get a hold of. That was part of why I asked to approach the bench, but
He's
I understand
been
there's
held up. He was in court here Monday, so I don't know
Okay.
why he's not that difficult to get a hold of.
Okay.
Coming in on the date of trial, asking for an adjournment of these proceedings is not gonna happen.
And there it is, denied. Judges manage calendars like air traffic controllers. Trials are scheduled months, sometimes years, in advance. Witnesses arrange time. Court staff coordinate. When someone asks for an adjournment on the morning of trial without extraordinary cause, the presumption is against it. Judge Simpson makes it clear, resolve it, or try it. That is a strategic squeeze. Settlement pressure just increased dramatically. Notice the lawyer immediately requests a recess to speak with defense. That's smart. When the court signals it won't delay, settlement discussions become urgent. And here's something subtle but important. The judge didn't say the motion was legally invalid. He said it's too late. Timing can defeat even technically sound arguments. If you were counsel, why would you push forward and risk losing at trial or pivot towards settlement under pressure? Because the hallway conversations about to happen may decide everything.
Okay.
So you guys either can try to resolve this thing, or we're gonna try it.
Okay. Fair enough. Then I would request a brief recess to please speak to the defense.
Okay, see if you guys can work it out. Court's gonna stand in recess. Back on the record, court does call the case, Finney versus Sedona. All the parties are present, and how did the conversation go?
It wasn't entirely productive, Your Honor. So we have, back from 2021, a consent order for conditional dismissal. There was an eviction order entered after that time against the defendants. As it relates to today's full bench trial, it is based on a counterclaim that was filed on February 12th, 2021. However, again, it's my position that the counterclaim needs to be dismissed. There's not actual cognizable claims under the counterclaim, so that it would be right for dismissal under MCR 2.116C.
Why are they not cognizable claims?
The claims are not cognizable as defendants are now pro per in this case. This was filed by their previous counsel. There is not a cognizable claim in regard to the condition of the property as against my client for relief.
Why is that not cognizable?
Can you repeat the question?
Why is that not cognizable claim?
It's not a cognizable claim, Your Honor, because there is a conditional dismissal entered as it relates to the original complaint where the defendants were being sued for the non-payment of rent, where the counterclaim asserts a generalized claim without any sort of reference to a breach of habitability or constructive eviction. The way that it's written in this counterclaim, it's more pertinent to the affirmative defenses, given the case history here and the fact that there was an eviction order entered. At this time, this can't be a cognizable claim before the court.
That doesn't even make any sense.
That line lands hard. When a judge says an argument doesn't even make sense, that's not just disagreement. That's a signal the court finds the legal logic flawed. The attorney argues that because there was an eviction and conditional dismissal, the counterclaim can't stand. But Judge Simpson pushes back with a basic principle. Just because someone agreed to vacate doesn't erase potential monetary claims. And he's right, legally speaking. Contractual or property disputes often survive eviction proceedings. If tenants allege damages, ownership disputes, or improper conduct, those claims can exist independently of possession issues. This is where legal nuance matters. Landlord-tenant courts often have jurisdictional limits, like the $25,000 cap mentioned earlier, but exceeding that amount doesn't automatically invalidate a claim. It can trigger transfer, it can limit recovery, but it doesn't magically erase the cause of action. So when the judge challenges the reasoning, he's protecting procedural fairness. Let me ask you, do you think this is a genuine jurisdiction issue or an attempt to shrink the battlefield before trial begins?
If somebody if somebody says I paid 1,000 or rent was $1,000 a month, I didn't pay the $1,000, and actually I was living in conditions that um, I think the landlord may owe me money because I paid them or something happened to the unit. The very fact that there was an agreement to vacate the premises doesn't negate their claim for money. As it wouldn't the landlord, if the landlord had a claim for money.
Absolutely, Your Honor. My point is more towards, to back up slightly. This has been in court for a long time. There's a lot on the record, especially for something that started out as a non-payment of rent case. The defendants are the relatives of the plaintiff.
I'm aware.
There's
I'm aware of a whole lot in this case.
There are facts in the counterclaim that are very generalized. There's not a factual section or actual claims after that. It's very generalized, but it does assert that there's a dispute as to mortgage payments. There's a dispute as to ownership interest. So this is out of the realm of a landlord-tenant non-payment of rent case. And it's not a cognizable claim under the statutory law for those damages. Secondly,
And you keep saying that. Give me some case law that says that.
okay. Okay, I move on to a second point briefly and then return to that, Your Honor.
Go ahead.
Okay. Secondly, after the generalized facts in the complaint, then the defendants move on to enter under a claim of statutory conversion, common law conversion, excuse me. Well, okay.
Regarding the insurance money.
It's both. In paragraph 28, it's combined into common law conversion and conversion under MCL 600.2919A. Now, again, of course, Your Honor, we're considering what the language actually is in the counter complaint, but it's to my point that these claims are entirely convoluted. But they're asking for, as you would be entitled to under statutory conversion, 3 times the amount of actual damages plus costs and reasonable attorney's fees. If there's no summary proceedings to be had in terms of the possession of the property, and what's at issue here are ownership interests and statutory conversion claim that exceeds $25,000, it's in the beginning, as I was arguing to you, that this would be appropriate for dismissal under MCR 2.116C7. However, even if
jurisdictionally or under 7? Why under 7?
right. This is what I'm stating, Your Honor. In the beginning, maybe it wasn't helpful to move on to a different issue, but in the beginning, it's that there aren't cognizable claims that apply any longer, given the procedural history. Not only that, but also just the way that it's been written out here in terms of the habitability. I did need a brief moment to consult my information, but in terms of the habitability, the actual counts that would indicate that the legal requirements have been met are not enumerated. And then secondly, it would be appropriate under MCR 4.002, not necessarily to dismiss the action, but if it's related to property ownership, which is quiet title, and if it's related to conversion for a claim of over $25,000, it's not the court's obligation to dismiss it, but it would be more proper that this be transferred to the circuit court.
And have you asked for removal?
I would request a removal, Your Honor.
I'm not removing this case.
That's decisive. The attorney requested removal, essentially asking to move the case to circuit court due to jurisdiction and claim size. Judge Simpson shuts it down immediately. Why? Because timing and procedural posture matter. The judge explains he already clarified jurisdiction limits in prior conferences. The parties elected to stay. Years have passed. At some point, courts say, enough. You can't litigate for years in one forum and then, on trial day, argue the forum is wrong. There's also something strategic here. If the court removes the case, everything resets. Delay increases, costs increase, leverage shifts. Judges are cautious about enabling that kind of tactical maneuvering late in the process. And now tension spikes. The attorney objects to proceeding. However, the judge calls the arguments gobbledygook. That word is blunt, but it signals frustration. We're no longer just debating law. We're at a breaking point. Trial or collapse. The next few minutes will decide whether this explodes or settles. Next, push the limits.
I think it was, and you coming late to the game, I think I explained to the Sidonians, I don't have jurisdiction over the title.
Okay.
I also explained to them that my jurisdictional limit was 25,000. I explained that very clearly. I think I explained it actually to both sides during the couple of final settlement conferences that we had. So I don't know why it's being raised. They have elected throughout these number of years to have the case remain here. So at this point, I'm not removing it. Anything else?
I mean, I have to object to proceeding on a full hearing at this time.
On
For
what grounds?
the numerous reasons I've stated.
You stated a lot of gobbledygook is the only way I can explain it. You haven't given me a reason. You haven't given me a reason why it shouldn't proceed today. This matter has been set for trial today. I have given a lot of leeway to both parties, I think, in terms of trying to make sure to try to resolve this case, to try to find a way to do it, sent them to mediation. They went through basically a mediation with me regarding this case on a couple of occasions. And it's come down to the date of trial. And now you come in wanting further delay. And I'm not delaying this.
This is where courtroom control becomes unmistakable. Judge Simpson is drawing a line. Not just legally, structurally. He reminds everyone that this case has been mediated, conferenced, discussed, and delayed over years. That context matters. Courts operate on finite time and resources. When a matter lingers this long, judicial patience thins. The attorney frames it as doing right by her client. That's ethically correct, but timing is everything. Judges balance fairness to one party with fairness to the system. And at this point, the judge is signaling system integrity wins. Notice the subtext here. When a judge says, I've given a lot of leeway, that's documentation on the record. If there's an appeal later claiming unfairness, this transcript shows procedural opportunities were provided. And then something subtle but powerful happens. The request to go off the record. That means things are sensitive. Settlement pressure. Client control issues, possibly contradictions. When a judge agrees but gives strict hallway behavior instructions that tells you tensions are high, this is no longer just about claims. It's about credibility, leverage, and whether the attorney fully understands what her client has previously represented to the court.
It's not that at all, Your Honor. I just want to do right by my client. I was hoping I could approach the bench. I understand there's not another attorney and a party will also have to be able to. But I would like to go off the record for a moment if it's acceptable to you.
Do you have any objection to that, folks? No. All right. I don't know how we're going to have this conversation, but let's do it this way. We can go off the record. Mr. Trapp, take both parties, behave yourself when you're in my hallway, take them back to the jury deliberation room. When you're seated in the deliberation room, I don't want either one of you saying anything to anybody until I get there. We clear? Ma'am, am I clear, Ms. Finney? All right, take them back to my jury deliberation room. And the court will stand in recess. My understanding is the parties have had further discussions. Did, anything come out of that, or are we still?
Yeah, talk.
Sure.
When we came back in, she asked us to step out in the hallway. And when we stepped out in the hallway, she proceeded to tell us that pretty much if we don't take the $5,200 in escrow and walk away today, that she's gonna file a lawsuit against us in a different court, that you won't be our judge, and it'll be over $25,000.
And now we're in dangerous territory because settlement communications just leaked into the record. Normally, what's said in settlement talk stays off the record. It's protected. But here, one party brings it up publicly, accusing the other side of threatening a larger lawsuit in a different court. That changes the tone instantly. Strategically, that alleged statement makes sense. If the amount in dispute exceeds the court's jurisdictional cap, the plaintiff could refile in circuit court seeking over $25,000. That's leverage. But when presented as a threat, it can feel coercive. Judge Simpson immediately pushes back, noting there were inconsistent representations made earlier. That's critical. Judges remember what parties say on the record. If today's position conflicts with earlier statements, credibility takes a hit. Then the attorney moves to withdraw. That's huge. When counsel says she cannot reasonably represent her client due to factual inconsistencies, that signals internal breakdown. Attorney-client trust may be compromised. Ethical obligations may be triggered. This is no longer just litigation strategy. This is professional survival.
So no money matters. She didn't want to talk about the money matters again. So she said escrow only. So I just leave it in your hands, Your Honor. I don't know what to do anymore.
Completely misconstruing what I said. We shouldn't even be talking about settlement matters, but I made a valid settlement.
Counselor, if you don't want to talk about it, don't talk about
Yeah,
it. It's not going to make a difference to me.
right.
I mean, you know, I'm just going to say this. I mean, we go back there and talk. Your client, I'm going to let you put the testimony on, but there are certain representations that she's made to this court that you may or may not be aware of, because you got caught with one. I'm not saying caught in the sense of whatever, of a statement that she made, which is absolutely contrary to what she said before.
Right.
All right, are we ready to try this?
To be let off the case at this time?
You're looking to withdraw?
Yes. I can't reasonably represent her if I'm going to misconstrue the facts.
Well, it's not an issue of you misconstruing the facts. I'm just telling you that there have been certain representations made on the record, which I will tell you were different than what was said today. And I will tell you, counsel, I can tell by your reaction that you did not know that. So if you are going to move to withdraw, I'm going to step off, and you probably need to have a detailed conversation with your client about that. The court's going to stand in recess. Everybody can remain seated. Court does call the case of Finney versus Sedona. Parties are present. The record should reflect I've had an opportunity to talk with the parties, and parties have come to a resolution.
And just like that, resolution. After all the tension, jurisdictional battles, fraud allegations, withdrawal motions, it ends in settlement. $10,000 total, $5,263.17 released from escrow. The remaining $4,736.83 paid over 2 years at $197.33 per month. That level of precision tells you this was negotiated carefully. But here's the real pressure point. Default triggers an additional $5,000 penalty. That's a built-in enforcement mechanism. Miss payments? The number jumps dramatically. That clause ensures compliance. Notice also the judge confirming satisfaction from each party individually, especially after earlier credibility issues. That's intentional. It protects the agreement from later claims of coercion, and the attorney's withdrawal will be granted after the order is signed, meaning she closes the case cleanly. What began as a landlord-tenant dispute evolved into fraud allegations, jurisdiction fights, and nearly a breakdown in representation. And yet, it resolves through structured compromise. Sometimes trial brinkmanship produces settlement clarity. But we're not done. The docket shifts again, this time back into criminal territory, where the stakes become far more personal.
I'll state it on the record and then ask for the concurrence that that is the agreement. Parties have agreed to a full and final settlement of all claims that could have been raised in this case or have been raised in the amount of $10,000. That will be in favor of the Sidonis. That $10,000, the amount of $5,263.17 will be released to the defendants from court escrow. The remaining amount of $4,736.83 will be paid by Ms. Finney to the Sidonis in monthly payments over a 2-year period. And counsel, that amount, what was the amount per month that you came up with?
That was $197.33.
All right, per month for 2 years. When did she wish to begin those payments?
Next month.
April? Okay, is there a particular date in April?
Like the 30th.
The April 30th, would that be acceptable to? All right, beginning April 30th, 2025, until that is paid in full. Should the defendant miss a payment, default on the payments, an additional amount of $5,000 will be added to the $10,000 figure. The Sidonis would then be entitled to a judgment in that amount, less any payments, which is inclusive of the escrow that have been made. All right. Also, I am the oral motion of counsel to withdraw once the order has been prepared. I will grant that. So that after that, the order is signed, she will have no further obligation to this case unless she undertakes it in some other way. That's the court's full understanding of the agreement of the parties. I'll start with you, Ms. Finney. Is that your understanding?
Yes, Your Honor.
Do you have any questions whatsoever regarding that? And I will ask this because of what occurred. You are satisfied with the efforts of your attorney in representing you today in this matter?
Yes.
All right, great. To the Sidonis. Mrs. Sidoni, is that your understanding of the agreement?
Yes, sir.
Do you have any questions regarding that agreement? And you are satisfied with that agreement? Mr. Sidoni, is that your understanding of the agreement?
Yes.
Do you have any questions regarding the agreement? And are you satisfied with the agreement? All right, very good. I will await the order, then I will sign it. I will thank all of you for working this out today. It has been a long haul, but I think it certainly has resolved in the best interest for all of you. And I wish all of you the best in the future. All righty. Thank you.
Thank you so much.
Court calls case People versus Michael Collins.
Good afternoon, Assistant Public Defender Laura Kearney on behalf of Mr. Collinson. Mr. Collins, please state your name for the record.
Michael Scott Collins.
Teresa Claire on behalf of probation. Your Honor, Mr. Collinson is before the court for a violation of probation hearing. Mr. Collinson is in violation of the terms ordered by the court in that he.
Now we shift into a very different category of courtroom tension. Probation violation. And this one is heavy. Multiple failures, unpaid balance, failure to report, failure to attend treatment, new criminal charges, and even a pending felony involving a financial transaction device. This isn't a technical violation. This is accumulation. Probation is conditional freedom. When someone is sentenced but allowed to remain in the community, it's based on compliance, reporting, treatment, no new crimes. Once you start stacking violations like this, the court begins to see pattern, not mistake. Notice probation recommends 365 days in jail. That's the maximum leverage tool available at this level. They're essentially saying rehabilitation hasn't worked. Structure and confinement might. But here's something critical. They're also willing to credit 146 days from Wayne County. That's discretionary. Judges don't have to grant credit for time served elsewhere unless it's legally tied. So already we see flexibility on one side. and frustration on the other. This case is about addiction, relapse, and repeated opportunity. The question now, will Judge Simpson prioritize treatment or finality?
Has a balance of $1,270. He's made no payments and has a payment plan arrearage of $525. He's failed to report to probation as directed, failed to return a signed copy of his probation order, failed to complete John Farm outpatient, failed to attend 3 AA meetings per week, failed to provide proof of employment. He has new criminal cases as well, Your Honor. One out of the 15th District Court of Retail Fraud, third degree, with an alleged date of expense of 7/24/24. He has a pretrial in that matter on April 2nd. He has a case out of the 35th District Court of possession of dangerous drugs. Alleged date of offense is October 6, 2024. That case is in bench one status. And he also has a pending felony, a financial transaction device illegal use, alleged date of offense of March 8, 2025. He is scheduled for PCC on April 3rd in that matter. On the case of the financial transaction device on that date of offense, in the police report, it alleges that police located a small baggie with a white crystalline substance and a glass pipe with a bulb at one end containing a white powder or residue on his person. It's probation's belief that Mr. Collison has continued to use drugs. Given the totality of Mr. Collison's violations of probation and his absconding, probation is recommending that the court sentence him to 365 days in jail. And Your Honor, the counsel did provide me with some documentation where he did some time in Wayne County and on 2 different dates, which would be during his absconded time. I do not oppose the court getting credit for those days, which would be 146 days total.
Well, what was he?
Your Honor, he went into Wayne, 2 separate times. He also was released to treatment on a tether. And then he again returned to jail in Wayne and was released on January 9th. So part of that time, he was absconded from his probation period.
I don't see why I would give the credit, but okay.
I'm not opposed to it. I would leave it to the court's discretion. The total credit that he does have serving in this county is 19 days. If the court considers that, the total credit, which includes the 19 days here, would be 146 days.
Got it. Okay.
That Mr. Collison served the balance of that jail time, that he completed in jail John Farm program, waive remaining terms, accept his financial obligations, and discharge him from probation without.
I did speak with Mr. Collison regarding this matter. He's asking the court to essentially keep him on probation and sentence in order him to do a long-term inpatient program. This case has been pending for some time, as the court has stated. It's from 2023. I was reviewing the notes in advance of this hearing, and Mr. Collison has seems like he's trying his darndest to do treatment. I was looking through all of the notes. He's been to Sacred Heart, Jefferson's House, Mariners Inn, Sparrow, Transitional Housing, Don Farm. He wants to be sober. There's lots of notes about his and communications with his caseworkers and social workers about his treatment. As the court knows, it can take many, many times for that treatment to stick. And that's why Mr. Collison is asking for additional time of probation to go to some other kind of program. Between sentencing and October, when he was picked up on a warrant out of Wayne County, he was going to AA. He was participating in the Pathways to Recovery program at the Lawn Center. He was doing outpatient treatment at Dawn Farm, and he did have a job at that time. When he was picked up on those warrants, I think it was about 74 days in Wayne County. He lost his spot in the Pathways to Recovery program, lost his spot at Don Farm. When he got out, he did try to get back into Pathways to Recovery, and get back into Don Farm, but he was unsuccessful in doing so. I did send an email the 35th to get him arraigned while he's in Washington County Jail on the pending warrant. So that's kind of in the works. But he is asking the court to sentence him to some kind of inpatient treatment. He has went to Bear River, and thinks that may be a good spot for him.
And Your Honor, probation would ask that the court keep Mr. Collinson in jail for some period of time. Mr. Collinson has been released to treatment, and he's picking up on cases.
Yeah.
And I think that he needs to have somewhat of a timeout, and then maybe complete the in-jail non-farm program, and then consider, a possible release to a long-term residential treatment program.
Sherry, anything you want to say?
I've been struggling with drug abuse since my mom died in a car accident, since 2018. I've lost my house, I've lost my kids, and I've lost my family.
This is one of those moments where the courtroom gets quiet. You can hear the humanity in what he's saying. Loss, a DHD methamphetamine, fear of sitting in jail for 365 days and coming out unchanged. This isn't denial. This is someone acknowledging addiction openly. And here's what makes it complicated. The defense attorney documented multiple treatment attempts. Sacred Heart, Jefferson House, Dawn Farm, AA meetings, Pathways to Recovery. That shows effort. Courts do consider effort. But relapse combined with new criminal charges shifts the calculus. Judges aren't just evaluating addiction, they're evaluating public safety and compliance. There's also something strategic in his request. He's not asking to walk free. He's asking for mandated long-term inpatient treatment. That shows awareness that structure is necessary. So here's the real tension. How many chances are too many? At what point does the court stop extending probation and instead impose incarceration to close the case? This is where philosophy of justice comes into play.
I really struggle with methamphetamine because of a diagnosis of ADHD with Adderall, and it's been extremely hard for me. This isn't who I am. This isn't who I want to be. I'm afraid of sitting in bars for 365 days and then getting out into the world and still having this addiction problem. I really wish I could deal with it. I almost agree that, some jail time is acceptable, especially because of my history, but I really do need the help of the court with treatments. If I could be mandated to an extreme program, a long-term program, it would really benefit me in my future. And,
I don't have a problem with that suggestion of release to treatment, but he has to be on a tether, and I'm not sure that that's going to be available to us. So I'm not going to order it at this point. All right. 365 days jail, credit 19. The balance is to be served.
I can't get the credit of the 90 days I just spent.
I'm not, I might consider it in terms of an early release, but at this point, I'm not giving credit for that. 365, credit 19 days, balance to be served. He's to complete the in-jail Dawn Farm program. I'll waive all remaining terms except the financial obligations, discharge from probation without improvement. Thank you.
Your Honor, if he completes the Dawn Farm program, will you consider a release then?
I will take a look at it. I'm not, I would release him to an inpatient program or some other type of suitable treatment. However, my understanding is we'd have no way to track it. And I'm not getting into that game.
Okay.
So as soon as somebody resolves that issue, then I'll certainly look at it.
Okay, thank you.
Court calls the case, People versus Andre Gibson.
So
I'll be in touch, all right? Good afternoon. Assistant Public Defender Lauren Carney on behalf of Mr. Gibson. And also Mr. Gibson, Your Honor.
Claire on behalf of probation. Your Honor, Mr. Gibson was scheduled before the court today for a violation of probation. He's not compliant with all terms, offered past and pending cases. Given his non-appearance today, probation is requesting a bench warrant.
Bench warrant for release for defendant's failure to appear. Bond will be set in amount of $25,000 cash or.
And this is the other side of probation violations: non-appearance. When someone fails to appear, courts respond quickly. A $25,000 cash bond is not symbolic. Cash means full amount up front. No percentage bond. That's serious. Failure to appear signals flight risk. And once the court views someone as unreliable in attendance, bond conditions tighten dramatically. This is about maintaining authority. If courts don't respond firmly to non-appearance, the entire scheduling system collapses. Notice how swift this is. No debate. Warrant issued immediately. Courtrooms run on compliance. When compliance breaks, consequences follow fast.
That warrant will issue immediately. Court calls case People versus Julius Gardner.
Everyone here on behalf of Mr. Gardner. Mr. Gardner, please state your name for the record.
Julius Gardner.
You know, we're here for sentencing. I did review the recommendation with Mr. Gardner. We do ask that you adopt it.
Sir, anything you want to say before I impose sentence? $125 statutory fee, 93 days jail, credit 74, the balance to be served. You're all set.
Thank you.
Court calls case People versus Kyle Zimmerman.
Good afternoon, this is the host of the board hearing on behalf of Mr. Zimmerman. Your Honor, I don't believe Mr. Zimmerman is present. I have not been able to get in touch with him. I did check Mind Link. I know the last time we were here, I think he was in custody. But unfortunately, I didn't. That he is in anywhere.
Bench warrant will issue bond $5,000. I'll give a 10% privilege on that. Warrant will issue immediately. Court calls case People versus Danielle Klimola. There's no counsel in this.
I believe that, I didn't see it reflected on JS, but I believe we were appointed, by Magistrate Odatella at, they ran that on the benchmark.
Oh, were you? Okay. That's fine.
I spoke with the arraignment attorney, they did fill out the appointment sheet for the court. I'm not sure.
Right. That's fine. Go ahead.
Okay. Oh, I guess you went to my face. Hi, good afternoon. This is the Post Federal Attorney on behalf of Ms. Vimella. Please state your name for the record. Yep.
Teresa Claire on behalf of probation. Your Honor, Ms. Klimola is before the court on 2 cases for a violation of probation. To update the court, the court did allow Ms. Klimola to be released from jail directly into Dawn Farm treatment. Probation did receive a report that she left Dawn Farm inpatient after being there for about 5 minutes.
5 minutes. That detail is devastating in a probation violation hearing. The court allowed release directly into treatment, a privilege, and she walked out almost immediately. From the judge's perspective, that undermines trust. The court extended an alternative to jail. It wasn't honored, but listen to the defense explanation. The treatment location triggered her. It was near where she used before. Addiction is highly environmental. Triggers matter. Now the court has to weigh 2 truths at once. She failed to comply. She may genuinely want recovery. Probation recommends 365 days. Again, maximum leverage. This mirrors the earlier case. The court is confronting repeated relapse and non-compliance. Will the judge repeat the same structured sentence?
At that time, probation did request from the court a warrant, and the court did grant that. So both of her cases were a warrant without bond. Since then, Your Honor, she has not reported to probation as directed. She also had a new arrest. I believe they may have entered that case today. When I prepared the report for the court, I only had the police report, which I did provide a copy to the court, with an alleged date of March 18, 2025. And a warrant request was submitted for 2 counts of resisting of sergeant officer and 1 count of possession of cocaine. Given that Ms. Kainola failed to follow through with the court allowing her to be released from the jail to do treatment, probation is recommending in both cases that she served 365 days in jail, credit for 66 days that she served to date, that she served the balance, that she completed in jail Don Farm program, waive remaining terms, accepted financial obligations, and discharge her from probation.
Junior was able to speak with Ms. Klimola regarding the VOP. When we discussed the Don Farm inpatient treatment, Ms. Klimola was very honest with me and indicated that the location where she went was very near where she used to use. That kind of triggered her and she left. But she did, however, report to me that she did return to Sparrow 3 times. She did make it to Don Farm once, but the area that it's in, it brought her back to the place she was while she was using. So she wants to do treatment. She wants to get sober. She has, again, she's very frank with me when we were talking and explained, that she's been struggling with substance abuse issues. And that she did get sober after she did treatment. About 8 years ago, she was sober for 4 years, then relapsed. And that's when she came back into the system. Before her relapse, she was doing well. She was had her own business. She was close to getting a degree at Washington Community College. She has family in the area that are supportive of her sobriety. So we're asking that the court consider sending her back to treatment again. Again, like the previous case, Your Honor, we know that with addiction, with substance abuse, it can take multiple times for treatment to, for lack of a better word, stick. I think Ms. Klimola is one of those where if she's been treated before, she's got sober, she was successful. I think that she can get there again with a little bit of help. And if she, actually stays at treatment, and isn't in a spot that brings her back to when she was, triggered back into that active addiction. So that is what we were asking for. I did see the complaint on that new case. It looks like the 2 counts for R&O were authorized. It's just 1 count of possession of cocaine. They are.
I actually have the file if you'd like to arrange her.
Oh, that'd be great. Yeah. I tried to get her arraigned today, but I think because they were bringing her here, they said the timing didn't work out. So, but I didn't want her to sit on bed. So.
Right. Okay.
Cool.
Got some.
Yeah, I can correct the time.
Got it. Okay. Your name? Let me do the arraignment right now.
Yep.
All right. You are before the court on a felony complaint that alleges that on or about March 18, 2025, location of 3505 South State Street, City of Ann Arbor, Washtenaw County, State of Michigan, that you did possess a controlled substance, that being cocaine, less than 25 grams. Do you understand that the nature of that charge, ma'am? That is a felony punishable by up to 4 years incarceration, $25,000 fine plus court costs. You understand that? You said yes?
Yes.
Okay. Do you wish to be represented by counsel? All right. This is a public defender case.
This is a little defender Lauren Journey on behalf of Ms. Klimola. We'll wait for her to stand to the charges, Your Honor.
Defendant, every way forward, reading standing mute to the charges. Court will enter a not guilty plea. I'll set a probable cause conference in this matter for April 10th, 2025, 9 a.m. As to bond in that case, I will set her bond. Since I'm going to sentence her on the case, I'm going to set her bond at a $10,000, 10% bond. All other standard conditions, including no assault behavior or possession of weapons. No alcohol, recreational marijuana, or any illegal drugs. I will enter a community corrections order requiring twice per week testing if she's released. Should take care of that case. Yeah. All right. Anything you want to say, ma'am, before I sentence you on the violation of probation?
Yeah. What my Tracy did. I take responsibility for, my addiction.
In each case, I'm going to sentence the defendant 365 days in jail, credit 66 days that she served. She is to serve the balance.
And yes, structured consistency. 365 days, credit 66, complete in-jail Dawn Farm program, discharge without improvement. This tells you something about Judge Simpson's philosophy. When community-based treatment fails or is abandoned, he pivots to structured custody-based programming. He is not ignoring addiction, he is relocating the treatment setting. Notice also he handled her new felony arraignment in the middle of this hearing. That shows docket efficiency, resolving multiple procedural steps in one appearance. The bond set at $10,000 with community corrections conditions reinforces oversight. This is firm but procedural, not emotional, not reactive. Accountability layered with conditional opportunity.
She is to complete the in-jail Dawn Farm program, and I will waive all remaining terms except her financial obligations, discharge from probation without improvement. And as I've said, that's to each case. Right. Thank you. Court does call the case of the people versus Shakari Davis.
Teresa Claire on behalf of probation. Your Honor, Ms. Davis is scheduled before today on the review hearing of a prosecutor deferred sentence. She did complete all terms ordered by the court, and I did waive her appearance. Probation is recommending that the court dismiss the case pursuant to the prosecutor deferred and discharge from probation. No objection.
So ordered. Court does call the case of the people versus Misty Perkins.
Good afternoon, this is a born attorney on behalf of the
Teresa Claire on behalf of today for a review hearing of a prosecutor sentence. She did complete all terms ordered by the court, and I did waive her appearance. Probation is recommending that the court dismiss the case pursuant to the prosecutor deferred and discharge from probation.
No objection.
So ordered.
He's refusing.
He's refusing. Court does call the case of the people versus Michael Kyle.
Public defender Natalie, on behalf of Mr. Kyle, who I understand is moving up, but he is still in custody in Washington County Jail. So I
Will adjourn the matter to April 9th, 2025, 9 a.m.
What we witnessed today is a cross-section of real courtroom operations under Judge Simpson. A clean misdemeanor plea resolved with suspended jail time. A civil landlord dispute that escalated into fraud allegations and nearly attorney withdrawal before settling for $10,000. Probation violations involving addiction, relapse, and new criminal conduct, resulting in structured 365-day sentences with treatment components. Bench warrants for non-appearance, efficient dismissals for successful probation completion, and procedural adjournments that keep the system moving. The pattern is clear. This court prioritizes record clarity, procedural fairness, and structured accountability. When people comply, they move forward. When they don't, consequences escalate. But treatment opportunities remain embedded within sentencing. It's not chaos. It's controlled pressure. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.